Good afternoon, everybody. Welcome to this afternoon's session. I hope you've all had your caffeine and cake fix. This afternoon we are talking about experts and lawyers' views on international arbitration. The aim is to talk through 5 topics of interest to international arbitration practitioners, although some of it will impact upon domestic work too, I'm sure. These topics are going to flow through the sequence of conventional arbitration directions from statements of case through to expert evidence. Each speaker is going to talk to their own topic, and thereafter the panel will discuss their own thoughts and experiences on the issues raised. We'll then move to the next speaker and so on through the process. There will be time for questions at the end. So we're going to start with Nick Brown of Pinsent Masons. Nick is a multi-jurisdictional lawyer, commercial arbitrator and adjudicator with 25 years of what is described as dedicated experience in the resolution of disputes on infrastructure and energy projects across Asia Pacific, Middle East, Africa and the UK, Central Europe and Australia, the whole world essentially. He's worked on disputes across the world relating to infrastructure projects and transactions including oil and gas, energy, transportation and mining. He's a regular legal writer in the area of construction law and international commercial arbitration. He's a visiting lecturer at King's College London and enjoys a good working relationship with a number of arbitral institutions, including, of course, the ICC and Singapore International Arbitration Centre. So Nick is going to start us off with the pros and cons of conventional pleadings against memorials in international arbitration. Nick.
Testing. Thank you very much, Alexander. Good afternoon, ladies and gentlemen. It's a real pleasure to be here addressing you. I will speak to a set of notes that I put together. I have to admit that the notes are based on the views of other authors and then my own sort of attempt to digest and assess for myself from 3 perspectives these points. As Alexander said, it's a question of which is to be preferred in international construction arbitrations between the approach of conventional or common law pleadings or the memorial style pleadings. Now, the perspectives that I think we ought to bear in mind in order of importance are business people, from the point of view of users of arbitral services, what's best. Secondly, arbitrators, the tribunals, what's best. And then thirdly, all the other professionals. Now, from those perspectives, I actually think there's probably a consistent view. The question is it pro-conventional or pro-memorial? Now, of course, if we were in another part of the world, conventional would be memorial, not common law. Forgive me, I was born in the Commonwealth. But let's just start with the conventional approach. In my view, I'll look at the relative advantages only to keep it simple. In my view, there are 6 basic advantages to the memorial approach and more advantages to the conventional common law approach, starting with the conventional common law. I think it's not front-end loaded so much. That is to say, it's more efficient if a case is going to be resolved without a hearing. Now that's because, of course, you start with a phase of the case expression in the formal exposition of what one party's position is in relation to their claim, without evidence, without reference to authority, without much argumentation, indeed there strictly shouldn't be any, just a statement of the facts that give rise to the cause of action. And so that's less expensive and can be produced quicker than a full-blown case statement. So it starts on the bell curve at a lower level earlier than the case of memorials. Secondly, the efficiency of issue identification. Now, all of these, by the way, points, they're all interrelated. They're all consequences of each other or the basis of others. The second point is efficiency of issue identification. So the main issues, primarily the facts, of course, are identified earlier in a conventional pleading approach because they have to be set down and responded to without evidence, without argumentation, but just admitted, denied, or not admitted. So you get to know what's in contest factually sooner. Thirdly, efficiency of evidence production, be that documentary evidence, testimony, be that factual witness or opinion testimony, or other forms of evidence. That evidence is not produced until you know the contest over the facts, be they basic facts or matters of opinion. So again, there's this rather efficient staggered approach to the development of the case, which means that when it comes to the production of evidence, you're not wasting time finding and producing evidence that relates to a fact that isn't in dispute. As an aside, there's a very good article that's just been published about modern witness statement taking, and I don't want to go on a tangent, but I do really commend that article because it's talking about what a modern witness statement ought to address. If you add that modern approach, one would say it's a return to the past. But in any event, if you consider the good wisdom of that article, which I'm happy to give you the details for, I didn't write it, then that would even amplify the benefits that a conventional pleading approach can offer. And then, of course, document production. In some senses, it's part of the last point I made about evidence production, because disclosure is the means by which one gathers evidence to produce. But again, of course, that is going to be limited, or ought to be limited these days, to what is truly material to the outcome of the case. So those, to my mind, are the main benefits of conventional pleadings. Turning then to the memorial approach. First up, reasonably complete picture of the case. So there you're getting to grips with the case sooner, at least from the perspective of the initiating party. The party lays out their stall in complete fashion right at the beginning of the case. Now, how would one consider that advantageous? Because it is laying out one's stall, making a commitment that this is the case that we are stating, proving, and arguing that the governing principles of contract and law support. So it's all out there. Now, one only needs to consider the risks associated of stating one's case in that fulsome fashion to then think, well, then what about the prospects of resolution? Because if one has to make that commitment sooner, then the prospects of understanding the risks of that case succeeding or failing will occur sooner. And so the chance of settlement and the chance of understanding the true issues, at least from that perspective, comes sooner. And that in itself can be efficient to the resolution of a dispute. But of course, the initiating party, the claimant, sets out a lot of information, and some of that information may not be contested by the responding party. So perhaps there's some wastage. Indeed, there is wastage if the claimant can't foresee what will be contested by the respondent. So laying one's stall out has its benefits, but perhaps a risk of wastage too. I've said then it may enhance the prospects of success, certainly when the responding memorial comes and one can see what issues are contested, then it's all out there, isn't it? Now, it can always be amendment, there can always be, you know, the development of one's case, and that's often in practice what occurs. But at least in first instance, on both sides, the entire case is exposed. And the other benefit of that, then it will filter frivolous claims. If one is making a claim for an ulterior purpose, then that will become swiftly apparent in the claimant's memorial, or ought to. assessing the evidential strengths and the weaknesses of the case will also come sooner, will be more apparent in a more fulsome statement. The oral hearing will be lessened if most of the case has been expressed in writing. There's less need to have the case articulated in an oral way. Case can, of course, be argued and enhanced orally, but there's less of a need for the oral hearing of evidence. So one can see efficiencies associated with the memorial style approach, and certainly in terms of resolving the disputes sooner, the prospects of that, in theory, that is a major advantage of the memorial approach. I'm going to be very interested in what my fellow panelists have to say from their perspectives as experts, advocates, and arbitrators themselves, because we all have our experiences of the reality of memorials versus common law pleadings. So I'd be interested to hear those comments. But for me, that's all I have to say. Thank you very much.
Thank you very much, Nick. Yes, can I ask our panellists for some thoughts? Gary?
Yeah, Nick, I mean, for my part, I think there's, I don't know if can everyone hear me with that? Is that, yeah. I'm not sure whether it's all about the timetabling generally, that from an expert perspective, I've been involved in conventional pleadings where somebody says we're claiming X hundreds of millions. It will be in our expert report, so we're not going to tell you how we build that figure up. And then the directions are that the experts are to produce reports. So I ended up in a situation in arbitration in that case where I had no idea what the case actually was that I was responding to. So I think it perhaps goes a little bit wider than just saying, is it memorial or conventional? Maybe you've got to look a little bit wider.
I think that's a fair point, because I think the conduct of the case in other ways must be aimed at getting to those issues as soon as possible. And it may be that pleadings of either nature will be amorphous as to what the true issues for expert opinion are.
Yeah, no, agreed, Nick. I mean, I think the point for me, I think, is if you can actually understand the case that's being made and the timetable is sufficient for each party to respond, I think with the memorial, you do have the chance of seeing that you know what people are saying from day one. I appreciate it's more front-loaded in terms of effort, but I think the sequential nature of it is perhaps more beneficial.
I think certainly I can see the difficulty with a memorial-based approach, particularly for a quantum expert. It's particularly acute because you don't have all the material or all the issues crystallised at the time that you're doing your initiating report. And so, particularly for a respondent, you're saying, well, what am I answering here?
Yeah, absolutely.
Yeah. Kim, any thoughts?
Thank you. So I've got 2 points to make. Let's not forget what this exchange of statements of case is actually for. It isn't to get everyone bogged down in a load of work for a period of time. The purpose is to define the issues. And tedious though pleadings are, they are very good at defining the issues. With memorials, it is much easier to obfuscate the issues, if that's the intention, or much harder to identify the issues, which ought to be the intention. And the other point is that from the tribunal's point of view, increasingly the parties ask for a really extended period in which to produce these memorials, and it's not unusual for them to ask for 6 months for the statement of case and 6 months for the statement of defence. And for the tribunal's point of view, that means by the time the pleading process is closed, they really have forgotten what the case was all about from the time that they were appointed, which probably wasn't the intention that the parties had.
Yeah, so overall, a longer timetable. And then there's the business, once the memorials have been exchanged, of gearing up for the hearing. Oh, what did I write, 9 months ago, and so on, as an expert, is difficult. Does anyone have any thoughts on Nick's suggestion that memorials might reduce the hearing length. I must say that's not my experience. There's still as much stuff to cross-examine on and investigate as there would be with conventional expert reports coming at the end of the sequence.
The hearing will be as long as the hearing will be.
Yeah.
And I don't think either process makes it necessarily longer or shorter. The secret to making your hearing efficient is to be clear about what it is that you're arguing about and making sure that your evidence is focused on those points. Now, if you're able to pull out from the morass of memorial material those issues and that evidence, then your hearing will be efficient. If you then have to revisit them all because everyone has, for want of a better term, lost the plot, then your hearing will be messy and chaotic as a result.
Yes.
There is, of course, an analogy, just to bring the theme of this conference right back to adjudications, of course, because in a sense, an adjudication submission is a memorial. And that seems to work.
You tend not to have a hearing
Yeah.
in the main.
That's true. That's true. Yeah.
Ah, well, that supports my point.
All right. Well, thank you very much, Nick, for that presentation. Next up is Dan Miles of Aquila Forensics Limited. Dan is a director and co-founder of the company. He's a chartered QS and expert witness with over 15 years' experience working on high-value complex disputes and has given evidence multiple times on many international arbitrations. He's a specialist in the provision of quantum advice and opinion in all forms of dispute resolution, including arbitration, adjudication, and mediation. And he's had many appointments and acts as advisor in disputes on various forms of contract, including, of course, FIDIC and JCT. Dan's topic is the practicalities of sampling in respect of evidence and document production in international arbitration. Dan.
Thank you very much. The one piece of good news of everybody listening to this next section is I've been told very firmly not to exceed 8 minutes. So I promise very hard to try and retain myself within that, because frankly, much more than 8 minutes on sampling is probably quite tedious for everybody. Taking sampling, though, I'll set my stall out at the start and saying I think it's a particularly important vehicle for minimizing costs and maximizing efficiency within arbitration. But I'd like to say at the start there are two forms of sampling. Number one, we have sampling in terms of validation of opinion, and the second form is validation of factual evidence. Discussing opinion, you'll see this more often, I would suggest, with technical experts. An example could be there's a defect within a highway. You may choose to take samples, core samples, from that highway at defined locations. So the opinion might be if there's a defect, and the sampling process is trying to validate that opinion. In a quantum realm, you tend to find it's more linked to validation of the factual evidence upon which you're relying. An example, just to try and bring this back, might be verification of cost to be included in a prolongation claim. Whether you want to take a cost as an indirect cost and a time-related cost into your prolongation claim, or choose to exclude it, will often have to be based upon the underlying evidence and the invoices supporting the cost claimed within a cost code system. The problem we have, though, is that even a small or moderate-sized project can easily have cost codes and cost data run into 10,000 or 100,000 rows of data. And in truth, it's not always practical to try and look at every single invoice for every underlying cost claimed within that prolongation claim. So to try and actually validate the cost being claimed, we'll often want to apply a sampling process to validate from the actual underlying evidence the cost being claimed. To do that, though, there's two elements that could be considered. Number one is an entirely unbiased, random selection of costs and invoices to review. But whilst everyone seems to favour this approach, it negates the fact you've engaged an expert, hopefully, with some expert opinion and some experience, who should be able to guide the sampling process towards the key areas that need to be reviewed. For example, you may have a concern over plant being costed and claimed on a project. Therefore, I suggest that actually what's needed is a mixture of both a biased and unbiased sampling approach. Unbiased, to make sure you don't miss anything, and a biased approach, using your experience, to target the areas that you feel most require the sampling to be done. I think I'm on 5 minutes. I've got 3 minutes left, so okay. So using that experience, we then hopefully can undertake a process to which we can validate, for example, cost codes and validate the categories of cost taken into our claims. And this brings us to the question of accuracy versus precision, and sometimes the veneer of precision. Where we have 100,000 rows of data, if we've gone through and looked at every single one, we may be claiming to be very precise in our work, but actually there's a veneer there, because it's very unlikely that somebody, and I am very culpable of this, when I was starting out in my career, I was given a 100,000 row spreadsheet and told to allocate, based on the criteria, all of the costs into a series of categories. It's fair to say, rather embarrassingly in the hearing, I have made some mistakes, largely because trying to go through that many rows of data, at some point you're going to misallocate and miscode a piece of evidence. However, on the same job, having looked at the cost codes, we established that the cost code allocation of cost was very accurate. And what we should have done is turn around and establish that out of 50 cost codes, 45 were accurate and correct, 5 were not, and 5 needed to be done on a line-by-line basis, and not all of them. Therefore, actually, the more accurate method would have been the sampling method, and the more precise method was simply the veneer, and not actually better for the overall assessment being undertaken. Which then leads us to consider what happens in document production within arbitration. So often, at the point of document production, that using a Redfern type approach, there's no opportunity to actually take a sample-based approach. Instead, we have costs being claimed, and we need to validate and verify those costs. So we ask for everything. Again, not a necessarily proportionate use of people's time, and so often you don't get everything. When you do get everything, you then realize you don't actually want everything, because you've now been given a 10,000 PDF document. You can't search anything, it's all been scanned in, and becomes an absolute nightmare. Therefore, within our document production, there could be benefit to actually experts agreeing what they want before we get to the Redfern, agreeing what data we need, and how we intend to use that data to undertake our analysis. This then goes to the next problem we have with Redfern schedules. We have to declare the category of documents that we want. The problem is, we often don't know what we want until we get it. What we know is what we want to do with it. We want to verify that the labour being claimed is correct. We want to verify how many people were present on site. We know what analysis we want to do, but we may not know what systems our contractor runs. Do they run a timesheet system? Do we have a log at a biometric log at a gate? How are we recording who is present on site? Therefore, what happens is you ask for everything, because you don't know what format the records are going to be in, so we include 5 pages of document request, when in truth, 1 line will be fine. I want to validate how many people were on site, on which days, and what job they were doing. Give me something that proves this. Instead, we ask for pages and pages of documents that generally get objected to, and when they do come, they're not in a format that we want. They're in a format which is not electronic, a format that we can't replicate and we can't analyse. So again, I would argue, where we can meet with our fellow experts and we can work collaboratively for the benefit of the tribunal, we have the ability to reduce the scale of our document requests and increase the efficiency with which we do our analysis. I think that...
Perfect.
Only a little bit over.
Perfect. Thank you very much, Dan. So, panel, what do we think on Dan's points about sampling and document production? Certainly in international arbitration, my experience is almost invariably the use of Redfern schedules. And the point that Dan makes is that they don't really work for experts, and is there a way around that? Has anyone seen a different route being put forward?
I guess it would only be, as Dan says, to get the experts together beforehand to see if they can actually identify what they can do. In fact, Dan and I worked on a case on opposing sides probably a year ago, had reasonable success in identifying samples. I guess for me, one of the points that came out about sampling, and it's probably more for Kim, Nicholas and Alexander, is that a colleague of mine was involved in an arbitration recently where he engaged in the sampling exercise looking at prolongation costs, sampled 80% of the documents only to find that the award from the tribunal was to say, we're not going to award anything for that portion that you didn't sample. Now that was a complete surprise to me. I don't know what thoughts might be on that.
Yeah, that would be a surprise. I think it depends on how the sampling is expressed. I think what the legal team would want to be making clear through the evidence of the expert is that by sampling whatever it is, the 80% or whatever, that the expert is expressing a positive view that he's satisfied or she's satisfied that that's a representative of the bit not sampled and therefore constitutes evidence, albeit of a lesser category, of the 100%. I think if it's only expressed as I've seen 80% full stop, then you fall foul of the problem. You haven't proved the 20%.
I think also just pick up that one, that there's a definite distinction, particularly within quantum, between sampling of the underlying factual evidence and sampling of an opinion-based element. And if your sample is now, we have 2,000 variations and I've sampled the accuracy of 150, then that's going to be a far more risky scenario because potentially each variation, there's a question of entitlement, there's a question of quantification, there's a whole series of underlying questions below that for which sampling may not be appropriate. From a quantum perspective, I think sampling is often more successful where we're discussing verification of the factual evidence rather than the opinion-based element.
No, I'd agree, Dan. I mean, I think in terms of the variation point, you then get into the interpolation and how you interpret those results. I mean, I've been involved in a case in that recently where we had to look at a number of disputed variations and then look to interpolate our findings. And I think that, again, leads to its own difficulties. Don't know what lawyers have to say about that.
You've been thrown the bus there, haven't you?
I'm wearing three hats today. I would say that there's a distinction between the legitimacy of sampling and the problem of getting to the data. And I think you're making those 2 points. As to the latter point, I would draw attention to the 2019 report of the ICC Commission on ADR, the report on construction arbitrations under the auspices of the ICC rules. You'll be aware the ICC is headquartered in Paris, and its rules are very much a hybrid of two traditions. And if you're looking at the point of view of data, getting access to data from a point of view that you're an inquiring tribunal, which is not necessarily the common law perspective, but you're going to get to the facts and you're going to have these experts help you get to those facts, then it's an entirely different scenario. What that report recommends as one solution to this problem of getting to the data is not only get the experts together early, but also have one of the members of the three-member tribunal sit with them and manage the acquisition of the data that they both accept they need, and to then agree what is the database.
And with your tribunal hat on, as the second of your three hats, what appetite do you think there is at an early stage when the tribunal don't really know much about the case? Would there be to intervene or supervise that process?
In practice, I'm sitting as a co-arbitrator in an ICC case at the moment. Chairman is a Swiss lawyer. I'm hoping he doesn't appoint me to go and sit in that meeting. And I think in practice it's very rare. And I think that's the magic of that report, because it's identifying what well may be a solution that isn't yet in practice.
Just jumping on that point, and I apologise for going out of the sequence for our topics today, but the flip side to that, I would suggest, also has great benefit. I've only seen one arbitrator do this, but I've seen them do it on 2 occasions, which is recognising that sometimes the tribunal can benefit from the skill sets of the experts. And particularly when an arbitrator asked us to sign documentation saying that we would support, in the case quantum, so we would support the arbitrator in the final calculations and check their maths without disclosing any information to the parties prior to the award being published. And there's benefit, I would suggest, going both ways there.
Just harking back to document production, my experience of it is that Redfern schedules and the process of production does very much assume traditional paper background, when of course, you know, that's not how businesses operate now. Everything is databases and search engines and so on. I'm not sure that the Redfern process is really cut out for that. I mean, you need to be able to give people access to databases, to search materials and so on. How easy has anyone found that in practice? And you deal with delay solely, I think. I mean, what is the sort of documentation you'd be trying to get access to?
The sort of thing that comes to mind, and looking at events recently, is the consequences of COVID and its impact on the efficiency on which site works are carried out. Sampling has sort of come up as a solution whereby what happens over the course of time is what, say, the contractor would say is that there are certain measures that I now have to instigate, which affects every member of staff and every operative on the site. So on a day-to-day basis, whereas you could, if you went back to your tender, you would be expecting to work 8 hours a day typically, that starts to be eaten into, and for various measures it might come down, say, let's say 6 hours. But it can vary from employee to employee and different trade and trade. So I did an exercise recently whereby sampling over fairly narrow calendar periods rather than, say, a overall period of 2 months, and used that as a basis by extrapolation to try and come up with a realistic figure or practical figure for how much time would be lost and associated with this. Now, these are still current disputes, and so the jury's still out, but I think that's an approach where it might be beneficial, rather than having to invest in what could be very intensive months and months of analysis of probably several analysts being involved, and then that, you know, it could be the scenario that all of that, depending on how the experts can agree on this, ultimately that might have to be repeated by the other side if they choose to dispute all the evidence presented.
This idea of having an interventionist tribunal at an early stage working with the experts either to choose representative samples or access to documents all sounds lovely and I suspect is in the interests of the process. But I think the practicalities are huge for it. With a tribunal hat on, there'd be real nervousness at an early stage with shutting out a limb of the case or misfiring on the selection and then finding out when you know a little bit more about the case a year down the track that you've sent everyone down the wrong rabbit hole. And so the default is, from a tribunal's perspective, leave it to the parties to try and work out the best way. We'll not tell you, but we'll tell you when you got it wrong.
I would suggest, coming back to Gary's point earlier on, is that actually, rather than the tribunal directing that sampling process where the experts are behaving sensibly and recognising their duties to the tribunal. It's for the experts to actually meet and agree appropriate sampling strategies and using their combined expertise to actually get to the data and to get sensible outputs that then everyone can be happy to rely upon and use later on.
And that is a particular area, isn't it, where the duties of an expert to the tribunal might clash with the duties to the client. Because you can certainly see the client saying, well, you know, I'm not letting them near that, or you know, I'd rather they chose a different limb of the project to be looking at, or whatever it may be, whereas the experts may take a different view.
Thank you. I think the debate does highlight the need for early involvement of the experts on both topics, because sampling works a treat if everyone agrees how it's going to be done and what it means. And by everyone, that includes the tribunal. And if they don't have that agreement, then the argument becomes about the sampling process rather than the merits. And I think that's what happened with that potholing case that Stephen Davis decided. And with the documents, equally, I think lawyers tend to be drawn to narrative form of documents. So that's correspondence, site-minute meetings, and written memos and records that tell a story, whereas the experts tend to be drawn to records, which lawyers tend not to want to look at because, you know, for them it's relatively meaningless. So you have this kind of clash of basic data, and it's not unusual for the lawyers to plead a case along a certain line and then the experts to dig out those records from behind the filing cabinet and discover that it's basically not quite how people saw it, either on liability or on quantum, and then there's the hoo-ha about whether you amend and so on. Whereas if the experts were involved at the outset, dug out those records, advised and informed the clients, and then that information went into the pleadings, then the whole procedure would get off on the right foot from the start.
Yeah, understood. All right, well, I think we can move from the topic of disclosure and sampling, thank you very much, Dan, to Kim's next topic. So Kim Franklin, KC of Crown Office Chambers, is, of course, a recognised specialist in construction engineering and the infrastructure sectors. Kim took Silk in 2016 and now acts predominantly as tribunal, resolving disputes from complex projects in international arbitration, dispute boards, and as a UK construction adjudicator. She's been appointed by the ICC, ADCCAC, and DIAC, there's lots of C's in there, DIAC arbitrations in the UK, UAE and GCC, and acts as sole arbitrator, party-appointed arbitrator and tribunal chair. Kim has a flair, as described, for technically complex, document-heavy disputes with a reputation for clarity, strong case management, and sound strategic judgment. And her adjudicated decisions are always met with judicial favour. See the Essex Waste case, which he describes as about as good as it gets. So Kim's going to talk to us about statements of witnesses of fact, particularly in international arbitration.
Well, thank you, Alexander, for that stellar introduction. I wonder who wrote it. So I've got a 40-minute talk on witness statements, which I've got to cut down to 8 minutes. If you see Alexander run and exercise the guillotine, you'll know why. Can I just talk about witness statements? So I want to look at this really from the tribunal's point of view. Tribunal were mentioned as one of the important people when it comes to how do you go about preparing your evidence. And let's look at this in a bit of a historical context, if we may. So back in the 1980s, which was when I qualified, the Technology and Construction Court introduced written witness statements to stand as evidence in chief. Before then, they didn't have that. Evidence in chief was given the long way round. Now, these were considered unpopular at the time by lawyers because they required too much work. Times have changed. Now witness statements are predominantly drafted by lawyers, and they do it beautifully. But the results tend to be that they're a bit on the long side. They don't necessarily reflect the witness's understanding or the language that they use. They are written in perfect English, which very often the witness doesn't speak. And there's a statement of truth at the end, which is sometimes signed on their behalf. The witnesses also dive in and argue the case a bit, taking side swipes at the opposition. There was a case, Riva Properties, against Foster and Partners, where the witness considered the term world class being applied to the architects as a bit of a hackneyed phrase, and the judge didn't like that. The witness statements tend to include evidential references which predate or postdate their own involvement, and reference to letters that they didn't write and meetings that they didn't go to. They often include the witness's opinions. And another cardinal sin is that they do not provide relevant evidence which the witness is actually best placed to give. And that's been coined as the dog that doesn't bark. So this relevant omission from the evidence is often more revealing than the irrelevant inclusions. And in short form dispute resolution like adjudication, it does entitle the adjudicator to make adverse findings. Well, you haven't dealt with this point because if you did, you'd have to admit that you got it all wrong. Now, these points were best illustrated when I was sitting as an arbitrator on my own in Abu Dhabi, and a commercial manager witness came along to give evidence, and the opening line in his statement was, "In my opinion, these proceedings are a complete waste of time." Now, it's never a good idea to tell the arbitrator that they're wasting their time, but particularly not when you are the claimant. And in this case, you were claiming for wasted management time. So, against that background, let's think about what makes a good witness statement. So a bit of context again. As junior counsel, I used to be asked to advise on evidence. And what did that mean? Well, it was done after close of pleadings, and my job was to work out what the issues were. I'd then identify the key factual events, who attended or witnessed them, and I'd list out the potential witnesses and the events they needed to cover. And then my instructing solicitors would go out and try and track down these witnesses. They'd prepare a statement and they'd report back to me on how they thought these witnesses would fare in the witness box. So times changed again. Later, I was just sent the draft witness statements and asked if the solicitors had missed anything. And sometimes they had, and usually it was on quantum. But then that stopped, and witness statements became increasingly detached from the issues, from the documents, and from the witnesses themselves. So a common trend, and this is particularly in arbitration, is at the end of a project where something's gone awry, a commercial director is brought in to try and mop up. So this director will read the file, they'll talk to the project managers, they'll dig about a bit, they meet with the other side, and if they can't sort it out, they instruct lawyers and they explain what's gone wrong and why. So the lawyers will take a detailed statement reflecting their instructions, and they'll proceed with that commercial director as their main point of client contact. And when the dispute goes to a tribunal, they submit that director's statement. If the director has strong views, and in my experience they usually do, they go into their evidence. Now at some point that director will be interrogated, and then it will become clear that the director has no first-hand knowledge of what happened at the time whatsoever. The tribunal would be entitled to draw a line through the witness statement. It would tell them nothing that they couldn't work out for themselves from the documents. It would be a colossal waste of time, energy, and resources. And also, it was a missed opportunity to provide the tribunal with the evidence that they wanted. So what's a good witness statement? Well, it's short. Let me say that again. It's short. It deals with the issues, and it only deals with the issues. It gives evidence of fact only. Any sentence that starts, in my opinion, is not evidence of fact and gets crossed out. It contains first-hand testimony only. I am informed that is not first-hand testimony. It's drafted by the witness in their language. And if their native language isn't English, they should explain how this statement came to be prepared. And if they don't speak Latin, they don't use adjectival clauses or the subjunctive, those should not appear in their witness statement. And if it's prepared with reference to the documents, it should be documents that they wrote, meetings they attended, and discussions that they held. So why go to all this trouble, you might ask, over a witness statement? Well, this actually is a good question, because construction disputes should be well documented. There's lots of photographs, there are records, and there's payment details. And if you haven't got them, you've got to ask yourself, why not? As I said earlier, I bet you they're behind that filing cabinet. Go and have a look. Delay experts tend to use those records rather than the correspondence and the witness statements. So very often, you know, the key expert evidence can be put together from records that don't require expert and witness narrative at all. You only need it to plug the gaps or to explain the photographs. Now, for nearly a decade, the courts have been worried about this problem. Back in 2013, there was a case, Weatherspoon and Harris, where they set out what they thought should be in a witness statement. And it's not until only recently, last year, that we had practice direction with the catchy phrase 57AC, which has an appendix and a statement of best practice, which applies to trial witness statements. Now, usually I put some nice slides up now so that you can see them. So I haven't got them, and I'm not going to read it out. But there are two important things in that direction: that witnesses verify their statement with a statement of truth, and that the legal representative certifies compliance with the practice direction. Paragraph 52 empowers the court to impose sanctions, including striking out offending parts of the statement. Sanctions sort of give a shiver down the legal spine and make them think that perhaps things are going to get interesting. And they just have. Recently, in a case called the McKinney plant, where objections were taken to the witness statements, which were rejected as being nitpicking. They went to see the judge about this, who took a dim view of the allegation of nitpicking and thought it was entirely justifiable, and awarded indemnity costs against those who had made the improper complaint. So these requirements now highlight the fundamental question: do you need witness statements? It requires thought and analysis. You have to identify the relevant witnesses and their evidence and the documents, and you have to tie it into the issues, which comes back to my earlier point. You can't produce evidence until you know what you're arguing about. Statements are going to take longer to prepare. They might be shorter. And you won't get a very good reception in court if you don't comply with these requirements. So I'll just finish on the point: what does all this mean for arbitration? Because the rules are slightly different there. Well, unfortunately, I do think it might mean an increase of the use of the memorial, because you need to get the documents in. You need, if you haven't got a witness who gives a kind of generic explanation of the narrative, project narrative from beginning to end, it's got to be given by the documents, and you want those in sooner rather than later. And tribunals can and will, and in my experience are increasingly keen to make CPR-style orders, particularly asking for those declarations. Remember, the witness gives a statement of truth and the solicitor has to certify compliance. I suggest you draft one that suits your own requirements. That's you, the practitioner, you, the tribunal, which will mean that the witness has to certify that they are giving evidence from their personal knowledge only. And let's see how that goes, shall we? Thank you.
Well, thank you, Kim. I think the difficulty, of course, is knowing or having sufficient confidence that the tribunal will work its way through the narrative story on the documents without the director's witness statement. True it is that it has no forensic value when he goes in the box, but as a collator of the document trail, it's very useful. And without that, and unless the tribunal have a narrative story that they can work through a chain of documents, there is a difficulty, isn't there?
Do you want to deal with that?
I'll just posit the suggestion that the pleading could contain that, so that it wouldn't be faux testimony. Well, that probably doesn't matter because it's seen for what it is. It's a story, a narration that assists.
Yeah. Gary, what's your experience of witness statements?
I'll now do the two-hatted thing, Nicholas, and say as an adjudicator, I don't find much benefit from factual witness statements. I find that most of them are self-serving, of little use, and probably set out exactly what Kim has said, the commercial director's view. Here's the case, this is why we think we should win. I think on a more positive note, where I've found witness evidence quite useful is when, as an expert, I've actually worked with counsel who've said to me, look, this is the case we're either making or defending. What evidence do I need factually that you can't get from the documents, and help me with that? And that's where I've found that particularly successful, that I've seen parties then focus, when they've worked with the experts, I'm sure maybe Russell will have a similar view on the delay side, that if you actually know what evidence it is you need to make the case, and it goes back to what Kim was saying about identifying the issues and understanding what it is you need to actually prove to win the case.
Russell, any thoughts?
On the positive side, I think often I do find on delay-related disputes, one of the major hurdles I have is a shortage of evidential material on which to base my analysis. And there are those instances where I think the phrase plug the gap is inevitably you have to refer to witness evidence to assist on that. And it's not unusual that you find your opposing expert is doing exactly the same. And in those circumstances, it becomes a little bit of a, not so much a battle of the, if you like, the credibility of the expert witnesses, but the witnesses of fact they're relying on. So that's one instance. Another one, and irrespective of which party is doing it, is sometimes it can be very, very beneficial, I think, from a tribunal for somebody who's lived with the project to actually just tell the story of what had happened from day one to the final completion. And just to put that down in writing, because sometimes I think as people who are not involved firsthand as experts, you know, we have to go through a learning curve to understand what actually happened and don't have the benefit of first-hand experience. So to a degree, we're less well qualified from somebody who's on the ground. Having said that, you know, I think I would agree with Gary, is a lot of the time witness evidence can be very self-serving. I recall one particular dispute where there wasn't a lack of, call it factual evidence in order to establish what delays had occurred on the job, because the contractor concerned had provided lots of progress information on a regular basis. the problem for him as the claimant was that that didn't actually support the contention he wanted to make, which was to assign responsibility for a lot of the delays on the job to somebody else. So in that instance, what they did is to use the project manager to provide witness evidence, which was along the lines of saying, well, although from a planning this was a power plant of a type, although we expect that from a planning perspective that we will need 100% of optimization in terms of power availability to start commissioning, he took a view that in his witness statement was well, we only needed 70%. So those activities which were affected by that, you can discount. We don't need to worry about those anymore. They're not considered critical. So he was running contrary to what was he and his team had actually reported at the time. I challenged this, and as a consequence of that, what I found was when my opposing expert, who'd relied on his opinion, came round to his second report, he abandoned this particular testimony. But lo and behold, the claimant pulled up another witness who would give, if you like, a similar view, but on a different basis. So no longer asserting that we needed 70% of power available, we just needed 90%. And you go through the mill again of having to try and discredit that witness once more. Suffice to say, that job settled shortly after. But I think in those circumstances, you do become cynical, and you can see often witness evidence is not being used in a very creditable way, I would suggest.
Well, we all like a rogue witness. Right, we're going to move into the expert phase of the arbitration process now. And Russell Bates of HKA is going to talk to us about the instruction of experts. Russell has worked in construction and engineering for over 30 years, initially in site planning before moving into consultancy work, particularly in relation to project delay. Over the last decade, he's been appointed regularly to act as expert in international arbitrations, has been cross-examined on various occasions in relation to projects, oil and gas, power and utilities, transport infrastructure, process, manufacture and buildings. Russell, as I say, is going to talk to us about instructions of experts. Thank you.
Thank you very much. The particular thought I had in mind to consider is whether or not there are instances is when a delay expert is instructed, whether or not those instructions become a device for actually, shall we say, limiting the remit or extent of the analysis to be being done. Now, perhaps as a starting point to distinguish that between instances where the instruction given itself inhibits the level of investigation to be carried out, where, and I've had a personal experience of this, where there are cost issues at heart, whereby either the client is unable to fully fund the costs of the arbitration, or is unwilling for one reason or another. He, as the respondent, is something of an unwilling participant. And so this was a big issue in terms of one particular dispute I was involved with. So instead of being permitted to do a fully independent report where I looked at all the facts, came and come to an overall view as to what did I consider to be the critical delays on the job, I was restricted to doing just what I call a negative type analysis, whereby all I was permitted to do was critique my opposing expert's report. So you can have instances of that. Another category that comes to mind is where the tribunal itself may, for one reason or another, decide to restrict the ambit of the analysis. And that's happened on a couple of occasions. Albeit, I have had a couple of instances where, notwithstanding what the tribunal has directed, my opposing expert has decided to go off on a frolic of his own, if you like, and actually introduce a lot of new information and a lot of analysis that the tribunal clearly directed him not to do. In one particular instance, it actually worked because the tribunal didn't throw out the information. Is that what they decided to do is to say, well, I think what we should do is consider that as a possible alternative option, and we will take a view later on when we come to give a look at our award. So there's those sorts of scenarios, but I distinguish those between instances where it's not where somebody's tried to limit what I say or do, but certainly in instances where the opposing expert, when I look at the instruction they've been given, and when I say instructions, there's very much, when you read an expert report, it'll be very structured, and somewhere at the top of the report, possibly just before the executive summary, there'll be a terse statement saying, this is what I've been told to carry out. However, it's not unusual, but if you sort of work through the body of the report, you actually find that, well, the expert is actually being instructed not to do certain things. So in one particular instance, what I found was that and it was kind of squirreled away, is two issues. One, first of all, is in terms of assessing delay by reference to the contractual provisions, the job in question was a little bit complicated because it involved an offshore contract and an onshore contract. What became clear is that he'd been instructed solely to analyse the project in relation to the onshore contract and ignore the offshore. That was important because there were certain conflicts, if you like, in terms of milestone completions between these two documents. So from my perspective, you always needed to take into account both. Secondly, it was very clear that in his remit was to define and only look at events within a very narrow period of time. Whereas I think what I ultimately found is that there was a lot of pertinent issues in terms of what happened before and what happened after. But that's something that only became clear after disclosure. So you have those instances such as this where it looks very much as if, in terms of what the instruction is trying to do, is sort of narrow very much the area which they're suggesting is the tribunal should be looking at. Another instance which arose not from a claimant, but where the respondent put in a counterclaim, and as part of that counterclaim they added the evidence of delay expert, albeit that, again, that evidence was very narrowly drawn in terms of what he was instructed to do was to look at a very limited number of documents and form a view as to what was therefore causing a critical delay to the project. It was a hydroelectric power scheme, so although you're building this huge dam and lots of other structures, the only information he was given to analyse was the construction of the turbine house and the fit out of the turbine house. So inevitably he came to the conclusion that delays to the turbine house were causing critical delay. The only problem with this is some of the documents that he'd given, which was a contentious point at the time, the other party was a very, very clear view that they'd been doctored. So not only was, if you like, the remit very limited, but there's an element of fraud to it, you could say. So, pocket there.
Thank you very much, Russell. Any thoughts on instructions of experts? And particularly, I'd be interested if anyone's got any experiences of different approaches being taken from experts in other jurisdictions, and whether the problems they encounter are similar to ours. Dan?
I think the one we've seen quite a lot when it comes to jurisdictional differences is I've seen opposing experts being instructed not to engage in joint statements and in valuing the figures as figures and the alternative case. So you'll have an expert who will only engage in their own legal pleaded case and have been instructed by the instructing solicitors to then not engage in valuing figures as figures, which I would suggest backfires, because if, as somebody always has to, you lose your legal case, you've then only got one set of numbers or one set of analysis to then consider. Apart from a list of criticisms, there's no positive analysis being presented by the other expert, which I would suggest doesn't leave you in a particularly great place unless you're entirely successful in all the legal arguments.
Yeah, I'd agree with that, Dan. And I think just thinking about the whole, I'm instructed, I just don't think tribunals buy that particularly. I think that they look at that and say, well, that's fine, you've written that down. What tends to happen is you'll get to the hearing and somebody like Kim or Alexander is going to say to you, well, that's all very well, Mr. Kitt, you say you're instructed. What do you actually think? And then you're in that position where none of the parties give this any thought, I don't think. They think it's very easy, it's a let-out. We'll tell you you're instructed to say this, and therefore you don't have to give your true opinion. And I think, that's my personal take on it.
That's where the witness statement jumps in and says, this happened.
Yes, fill the gap. Now I'm wearing my construction litigation partner of law firm hat, and I just want to reflect a bit on the difficulties that one can find oneself in when drafting those instructions. Consider this, the client has a limited budget for this investment. Say the client's a claimant, the project has a budget, of course, that's it. The investigation is going to be costly. Let's consider its investigation into delay, just alone. Now, if it's an issue of whether the contract is interested in a prospective delay analysis or a retrospective delay analysis, the inquiry is very different depending on which side of that fence one has to fall, which side of that fence the tribunal ultimately will be persuaded is the right side of the fence. At that very point in time, the client can't afford both inquiries, and there isn't time perhaps for both. So you've got to take a position. You've got to come to a conclusion on the proper interpretation of those contractual provisions and the facts and the realities and all of the other considerations. We know what they are, but you've got to apply them and come to a view on what the instructions, what scope of inquiry you want the expert to undertake. But then there's that very visceral concern about, what if we're wrong? What if the tribunal, Alexander, Kim says, well, what do you think if you accept that the methodology ought to be retrospective and you've looked at it prospectively only? So it's a very uncomfortable position where the professional has to take a view. That isn't always the case, and often it's the way in which you scope the extent of the investigation from both perspectives. But then you come into the other, and I think quite serious concerns about, have you limited the evidence to which the expert has been allowed access? Because I think that's more of a concern for an expert than an expert that says, I was instructed that the proper approach that this contract dictates for determining this entitlement was this, and I investigated primarily accordingly.
I think certainly when you're dealing with quantum, there's a perennial difficulty with the instructions to the expert about how you value a particular claim, where the approach might be either, well, if I can't see an invoice or a sample of invoices, I have to put nil in the column, as opposed to an approach which says, well, I haven't seen any invoices, I haven't seen any supporting records, but looking at the story and the narrative, my hunch, doing the best I can to help the tribunal, is X, whatever that X is. It may not be terribly easy to cross-examine on, it may not be anything more than a gut feel, but it gives a steer that is some way between zero, based on audited records, and the maximum claim that's been concocted by the claimant's expert. And knowing where to go with the instructions to the response expert is quite a challenge, I think, on that.
I would suggest that that's the kind of prime example where you get to that figures of figures approach and being allowed to value the alternative, which is you're instructed that the correct interpretation of the contract is without this evidence, it should be nil, your primary assessment will be nil. In a reply report, or where we're on pleadings memorials, there will be a legal pleading back the other way saying that actually it should be based on these principles for whatever legal reason. Your opposing expert will have valued it at a different number, and then in your reply report, you still maintain your reasons based on your instructions for why your primary is nil, but your alternative assessment, figures as figures, on the alternative legal interpretation will be a different sum for the reasons you set out in your report. Yeah. The danger comes where you don't engage in valuing figures as figures.
Sure. All right, well, we're going to move to the very last step or the last talk. Whether it's the last step is perhaps the question that Gary's going to talk about. Gary Kitt is the Senior Managing Director at JS Held. He's a highly experienced QS, chartered builder, chartered arbitrator with almost 40 years. Did you want to admit to that? 40 years experience in building and engineering projects worldwide. He's been regularly instructed as an expert witness on quantum and international arbitrations on major disputes across all sectors, including oil and gas, aviation, power and process plant, shipbuilding, major highway and infrastructure schemes, luxury hotels and retail malls. Can't think in which jurisdiction that took place. Gary is going to talk about experts' joint statement and, apropos the comment I just made, the timing of the joint statement. Should it be before expert reports, which we've just been talking about, or after, which is where we've positioned Gary this afternoon, and the content and extent of lawyer involvement in joint statements. Gary.
Thank you, Alexander. So, starting off, I should say it's a huge topic, and like you, Kim, I think 8 minutes, I'll do my best. I'm going to start with timetabling, and in my experience, I don't believe this is given much consideration by either the parties or tribunals. I say this because I've been involved in a number of arbitrations where the joint statement is directed either prior to service and exchange of reports, after service of the first round reports, and after service of reply reports, or a combination of all three. So what actually drives the timetabling? And from what I can establish, there's little rhyme or reason to it. I've asked a number of lawyers, I've spoken to various solicitors who've said to me, it's in the civil procedure rules. So will you show me where it is, I can't see it. Oh, well, it must be. Or they say, well, it's what we did on the last job. And I think it's a real problem. And you look at what the RICS say, so as a chartered QS, you look to the RICS guidance for surveyors acting as expert witnesses. And I'll quote this, they say it's generally best if such meetings occur before reports intended for disclosure are exchanged, as expert witnesses can be slow to alter opinions after signing a report. And it's often said that this approach saves cost. Well, I think you've got to consider what is the nature of the evidence that you're looking at that's forming part of the joint statement. I can see situations where, taking Russell's discipline, looking at delay analysis, it would certainly make sense to me that you might have a joint statement early to decide what's the baseline program that you're going to measure the delay against. What method of delay analysis is going to be used? Otherwise you get the two delay experts obviously choosing different approaches. But having said that, if you look at quantum, I don't think it does work, and I don't think it saves cost to actually do it before reports are exchanged. Now, I've been involved in many cases where you get involved after the timetable has been determined. Nobody actually asks the experts, and why should they? But you get involved and you're told, right, you're instructed and you've now got to produce a joint statement with the opposing expert on a number of variations, and you've got to do it within 3 weeks or a month or 2 months, whatever it is. What you find, or what I've found, is you've got to do as much work to actually form the opinion as you might do in actually drafting a report. So what happens? You're a little tentative. You don't necessarily form a considered view. So you produce this joint statement. The other expert, no doubt in the same position. You end up with a table of variations. You then do a first round of reports, so you can comment, but you don't really know what the other party's position is, because you've got the joint statement, it's not often in a lot of detail, and I'm going to talk about what should be in the content a little further on. So I think it's important to give it more consideration as to when that joint statement should be made. And I think there's a tactical issue as well here that I think is often overlooked, that I've been involved in cases where if the joint statement is done after the reports, you might get a situation where a particular expert has taken a very bullish approach on, let's say, lack of records, and he supports everything in his report. You then have the joint statement meeting and he reads your report and he says, oh yeah, I can see, that's all rubbish, I'm going to drop all that. So he concedes it all. But what he can't do, he can't actually withdraw that report. And I've seen experts get horribly taken down in cross-examination where they say, they're asked that question, why did you say I could support all of that? And the answer is, well, I've conceded it. I've now agreed it in the joint statement. And the question remains, but why did you say it in the first place? And it goes to, obviously, credibility. So I think that's a tactical issue. In terms of content, and again, whilst not directly applicable to arbitration, civil procedural rules give us a good guide. Part 35 talks about joint statements, identifying areas of agreement, areas of disagreement, and what are the reasons for disagreement. And I emphasise that because my experience generally is that lots of expert joint statements comprise nothing more than both experts' opinions. And they set them out in a table, Mr. X and Mr. Y. What you never see, or very rarely see, is that phrase, the reason we disagree is because. And it's obviously less confrontational just to put down two views. Now, when I was preparing this talk, Nicholas pointed out to me the ICC Commission report on construction industry arbitrations. Now, interestingly, paragraph 18.4 of that document states, too many joint expert reports are burdened with what is already known and accepted and don't concentrate on the reason for different opinions. And I just give one example of this. I was involved in a case where, and I'm going to contradict myself a little bit and say this was a case where the joint statement was useful to be done before reports. It was where we had to produce cost plans. So my suggestion to my opponent, who was also a chartered QS, was, why don't we agree that we'll prepare our cost plans based on the RICS NRM structure? Now, I thought that was fairly uncontroversial and ought to be fine. So I sent him a draft with that in there. It came back deleted. No, I don't want to agree to that. So I said, okay, absolutely fine. What we'll do then, we'll say the reason we disagree on the method is because you, Mr. X, and I left it ... You fill it in for me. And the next draft came back with that section then agreed. So I think it's a powerful tool for experts to actually put the person on the other side on the spot, say to them, what is the reason? How do we explain why we disagree? And I probably, it takes me nicely into my third point on lawyer involvement, because I feel that potentially there was maybe a little bit of pressure on, I don't know why you wouldn't agree to do a cost plan in accordance with NRM, but I think maybe this individual was told, we don't want to agree much. And I think Dan made the point that lawyers often say, don't get involved in agreeing this, that, try and do whatever you can. Now, I appreciate we're talking about arbitration, but if you look in the litigation sphere, obviously the TCC and the authorities take a very different view on this. There's the BDW case in 2018, a very recent case of Pickett and Balkind, I think a couple of weeks ago, seriously admonishing lawyers for interfering in the joint expert process where they actually want to be involved in the drafting, not just actually looking at defining what issues the expert should tackle, but actually saying, well, I want to see all the drafts and get involved. Now, my experience of arbitration is certainly that is the case, that lawyers do want to get involved, and it will be a topic for debate here as to whether that's right, wrong, or indifferent, but many of the cases I've been involved in, the whole process gets drawn out because every draft that is done, the expert sends it to the lawyer takes a day to look at it, they then return it, it's sent to the opponent, his lawyers take a day. Nobody actually admits that that's the reason it's taking so long. But there is an issue here that people, I think, are probably paying lip service to what the proper approach should be. So really, I suppose my final comment on that is, in terms of lawyer involvement, should it be all out in the open, or should the CPR rules and the recent cases in the UK be followed?
Gary, thank you very much. Kim, any experiences on joint statements and before, after, and or lawyer input?
Absolutely. So actually, Gary's made a very powerful case for treating quantum experts differently from delay. And from a tribunal's point of view, it's very important that the delay experts agree their methodology before they start work, because otherwise you have two competing methodologies, and how on earth is the tribunal going to decide between them other than by deciding between the experts? So they have to do some putting of the boot on one of the experts in order to say which methodology they prefer, which is not desirable and ought not to be necessary. So the sooner the delay experts can meet, the better. But I can see it's different for quantum because you need the numbers to crunch, and you're just going to be talking about things in the abstract otherwise. So I am going to make a mental note of that. Thank you very much. The joint statement is hugely useful for the tribunal. Now, it may be said that it's the only document the tribunal looks at. Well, if it is, I couldn't possibly comment, but who could blame the tribunal? Because we're back to the very beginning. What is it they've been asked to decide? They don't have to decide things that are agreed. They are only there to decide the things that are still in issue. So the joint statement, the more the experts can agree, of course, the happier the tribunal is. The more focus the experts can bring to the issues, the shorter the process will be, and the more useful the answer will be from the tribunal.
And it seems to me that there's if you are going to direct that the joint statements be after expert reports, that absolutely shouldn't be a reason to stop the meeting before. So the idea that they should meet at least to sort of snarl at each other and have a look and sort of discuss the themes that they're going to be covering in their reports, even if they don't end up signing an agreement, is still an appropriate course. You're nodding vigorously there.
So again, this may come as a shock to the parties, but the tribunal isn't interested in the tribalism that will have built up for the duration of the case. There's nothing more toe-curling from the tribunal's point of view to see the experts slagging each other off. It's not professional, it's not consistent with their obligation to help the tribunal, and again, it's just a complete waste of time. I was presented with a 70-page joint statement. When I went down the agreed column, I found one item of agreement. And I pointed this out to the experts, and they sort of said, oh, yeah, well, there's not much, is there? And I think, how is this helpful? What have you been spending your time doing? And if you can't, so this was an earlier point, if you can't agree the other party's approach, can you not at least value it? Because you never know, I might agree it, and then if I haven't got the alternative valuations, then we're either going to have to come back and go through the grisly process again, or I'm going to lose patience with you all and find against the greatest rule breaker. So if I could urge the experts to remember, they have to rise above the foray and be as helpful as possible and as professional as possible in their dealings with each other for the benefit of the tribunal.
Yeah, Nick, any thoughts?
I agree with what you said, Kim, completely. And just on that, I think any form of witness tampering, even a professional witness, is completely unacceptable. International arbitration is self-regulating, and it's global. And so there's a lot of it going on in international arbitration, but it's completely unacceptable. On the point of early meetings prior to exchange of reports, I also agree, Alexander. There are surely things that can be agreed at a first meeting, even if it's, recognition of the other person's details and CV and what are going to be the uncontroversial sources of information that both parties will be interested in. All of those things can surely be agreed. If an expert witness doesn't have the confidence of his or her independence, then that may be a problem. But I think a first meeting for as much of the preliminaries is well worth it. And that then gets the two individuals in the single discipline into some sort of appropriate dialogue in the interests of correct decision.
Any experience, Dan?
So coming back to my earlier topic of document requests, I will start by saying I agree with Gary that actually trying to pin yourself to your final opinion before you've done your report is not helpful. It's not until you've actually done the analysis can you come to the conclusion as to what your opinion is. But there's definitely benefit and merit to early expert meetings on targeted questions. And the more interesting the matter is, the more that becomes a benefit. So where there is questions over approach to methodology, approach to documents you require, and actually having those early conversations, not saying what your conclusion is, but at least agreeing sometimes your approach or what you need to get to a conclusion can be beneficial. But it is entirely dependent upon the willingness of the other side's expert to engage in constructive conversation rather than not.
Thank you. Right, I see we're nearly out of time. We've obviously covered pleadings against memorials, sampling and document production, witness statements, expert instructions, and timing and content of joint statements. So we've covered, I think, everything except the award, which we obviously won't be doing today.